The petition for writ of certiorari is denied. Justice Alito took no part in the consideration or decision of this petition. Justice Gorsuch, with whom Justice Thomas joins, dissenting from the denial of certiorari. For centuries, Western Apaches have worshipped at Chichibidikote. They consider the site a sacred and direct corridor to the Creator. It is a place where tribal members conduct religious ceremonies that cannot take place elsewhere. Recognizing Oak Flat's significance, the government has long protected both the land and the Apaches' access to it.
No more! Now the government and a mining conglomerate want to turn Oak Flat to a massive hole in the ground to extract copper lying underneath the land. They plan to blast tunnels that will create a crater, perhaps 1,000 feet deep and nearly 2 miles wide. It is undisputed that the government's plan will permanently destroy the Apache's historical place of worship, preventing them from ever again engaging in religious practices at Oak Flat.
Sacred site, Apache Stronghold, a non-profit organization sued under the Religious Freedom Restoration Act of 1993. That law prevents the federal government from substantially burdening a person's exercise of religion unless that burden represents the least restrictive means of furthering a compelling governmental interest. In a sharply divided and banked decision, the Ninth Circuit rejected Apache Stronghold's challenge. Though the government's plan will result in the destruction of an ancient sacred site, the Ninth Circuit reasoned the plan does not impose a substantial burden on religious exercise. Apache Stronghold asks us to review the Ninth Circuit's extraordinary conclusion, but the court today turns aside the group's request. Respectfully, that is a grave mistake. This case meets every one of the standards we usually apply when assessing petitions for excerpt that I read. The decision below is highly doubtful as a matter of law. It takes a view of the law at odds with those expressed by other federal courts of appeals, and it is virtually important before allowing the government to destroy the Apache's sacred site. This court should at least have troubled itself to hear their case. Oak Flat is home to old growth, oak groves, sacred springs, burial locations, and a singular concentration of archaeological sites, testifying to its persistent use for the last 1,500 years. Western Apaches believe that the site is the dwelling place of the gun, saints or holy spirits that lie at the very foundation of their religion. The going live and breathe in Oak Flat. They come from the ground and they serve as messengers between us and the Creator and in the physical world. Faithful to their beliefs, tribal members have worshipped at Oak Flat for centuries, conducting there a number of religious ceremonies that cannot take place anywhere else. One example, the sunrise ceremony, is a multi-day coming-of-age ceremony for young women. In the ceremony, a young woman's godmother dresses her in the essential tools of becoming a woman, and tribal members surround her with singing, dancing, and prayer. The ceremony depends on Oak Flat in many ways. It requires the Apache girl coming of age to gather certain plants from Oak Flat. Plants the Apaches believe to have the spirit of Chichibidagote. The gone later come from the mountains, enter Apache men called crown dancers, and bless the girl. On the third day of the ceremony, the girl is painted in white clay from the ground at Oak Flat. The clay represents the Apache creation story, in which a white painted woman came out of the earth, covered with white ash from the earth's surface. When an Apache girl is painted with the white clay, it molds her into the woman she's going to be. And she is imprinted with the spirit of Oak Flat. Her grandmother wipes the clay from her eyes, and the girl is reborn, transformed into womanhood. Tribal members believe the destruction of Oak Flat will close off a portal to the Creator forever, and will completely devastate the Western Apache's spiritual lifeblood. For the woman who came of age at Oak Flat in particular, that means their ties to Chichilbundagata, and to all the other girls past, present, and who have had their sunrise ceremonies there, will be severed. Absent that connection, Apache women say they can't call themselves Apache without the spirit of Chichilbundagata. There's nothing at all.
Although Oak Flat sits on federal land today, it was not always so. Once Western Apaches enjoyed a vast territory that embraced Oak Flat. With time, of course, others laid claim to the land. Among those was the nation of Mexico. For a period, it asserts rights to large swaths of what is now the American Southwest. That changed after the Mexican-American War, when Mexico ceded its claims by treaty to the United States in 1848. A few years later, the United States and the Apaches signed a treaty of their own. In it, the United States promised that it would, as its earliest convenience, designate, settle, and adjust territorial boundaries with the Apaches. But the U.S. never formally complied with that promise. Instead, many years of conflict, known as the Apache Wars, followed. Eventually, the government forced the Apaches onto reservations, and they lost large portions of their homelands, including Oak Flat. Beginning in the 20th century, however, the government took some steps to protect the site. First, in 1905, the government created the Tonto National Forest, of which Oak Flat forms a part. Then, in 1955, President Eisenhower reserved a portion of Oak Flat to protect it from mining. Later, President Nixon renewed that protection, and as recently as 2016, the National Park Service
added Oak Flat to the National Register of Historic Places, in part because of the site's significance to tribal members. Those protections started coming under pressure in 1995 when the discovery of a copper deposit thousands of feet beneath Oak Flat. Seeking to exploit that resource, two multinational mining companies, Rio Tinto and BHP, joined forces to form Resolution Copper, and together they began lobbying Congress for permission to mine the site. Over the ensuing 2 decades, various members of Congress proposed at least 12 separate standalone bills aimed to requiring the government to transfer Oak Flat to Resolution Copper. Following hearings and testimony from tribal members, however, each of those pieces of legislation failed. That experience eventually led Resolution Copper and its congressional allies to try a different tact. Every year, Congress passes a bill called the National Defense Authorization Act. Some call it must-pass legislation. In 2014, the NDAA was 698 pages long and authorized hundreds of billions of dollars in defense spending. To that bill, legislators attached a last-minute rider regarding the exploitation of Oak Flat. That provision, called the Land Exchange Act, sought to accomplish several things. It authorized the government to transfer Oak Flat to Resolution Copper in exchange for other scattered parcels of land. It revokes the orders by Presidents Eisenhower and Nixon protecting the area from mining, and it directed the Secretary of Agriculture to prepare an environmental impact statement. After completing the EIS, the government must convey all right, title, and interest in Oak Flat to Resolution Copper within 60 days. In January 2021, the Department of Agriculture published an EIS. In it, the department explained that Resolution Copper's mining activities, using a technique called panel caving, would result in a crater between 800 and 1,115 feet deep and roughly 1.8 miles across. The department admitted that Oak Flat would be directly and permanently damaged by the subsidence area. Indeed, the Apaches tell us the planned crater overlaps almost entirely with the area sacred to them. Acknowledging that the planned destruction of Oak Flat would cause indescribable hardship to tribal members, the department considered alternative mining techniques, but it was rejected. Those alternatives, including that, while other underground techniques could technically be applied, they would substantially reduce the amount of ore that would be profitably mined. Now the planned destruction of Oak Flat appears imminent. Though the department withdrew its initial EIS shortly after issuing it in 2021, the government presented that it intended to publish a final EIS on June 16, 2025, and transfer the land to Resolution Copper on or shortly after that date. Seeking to halt the transfer and destruction of Oak Flat, Apache Stronghold filed suit under RFRA in 2021 when the department was prepared to publish its initial EIS. After the district court denied its motion for the preliminary injunction, Apache Stronghold took its case to the Ninth Circuit, where years of litigation followed. The first round of that litigation culminated in a split-panel decision rejecting Apache Stronghold's RFRA claim. The panel began by observing that RFRA prevents the federal government from substantially burdening a person's sincere exercise of religion, unless that burden is the least restrictive means of furthering a compelling governmental interest.
And because the government did not dispute that Apache Stronghold members seek to exercise sincere religious beliefs by holding ceremonies on Oak Flat, the panel recognized the first critical question it faced concerned whether the government's proposed land transfer and mining plans would substantially burden the Apache's religious exercises. To answer that question, a majority of the panel turned for guidance on an earlier Ninth Circuit case, Navajo Nation versus United States Forest Service. There, the Ninth Circuit had held that burden on religious exercise qualify as substantial in two and only two circumstances. One, when individuals are forced to choose between following the tenets of their religion and receiving a governmental benefit. And two, when individuals are coerced to act contrary to their religious beliefs by the threat of civil or criminal sanctions. Applying that test to Apache Stronghold's claim, the majority concluded that the government's plan would not substantially burden tribal members' religious exercises. Those plans may make worship on Oak Flat impossible, but the majority responded the government's plans did not force tribal members to reject their faith and thus did not offend RFRA. Disagreeing with the majority understanding of Navajo Nation and its application to Apache Stronghold's claim, Judge Berzon dissented. That, however, did not prove the Ninth Circuit's last word on the matter. After the panel ruled, the court agreed to rehear Apache Stronghold's case. You may think that decision would have marked a significant victory for the Apaches. After all, the destruction of Oak Flat would prevent them from conducting religious exercises, including one they believe can occur nowhere else. But rather than end its analysis there, a different and closely divided 6-5 majority of the en banc court proceeded to articulate a special exception to the rule the court had just recognized. While the phrase substantial burden generally reaches action that prevent access to religious exercise, the majority said, that rule does not apply to actions involving a disposition of government real property. And for that reason, the Ninth Circuit once again denied Apache Stronghold's request for relief. How the en banc court arrived at its conclusion is a story of its own. The court began by reciting some legal history involving the Free Exercise Clause and the First Amendment. The Ninth Circuit observed, this court asked whether the government's challenged action imposed a substantial burden on religion, whether that burden served a compelling interest, and whether the government's chosen means are narrowly tailored. Later, the Ninth Circuit continued, this court appended that approach in Employment Division Department of Human Resources of Orr v. Smith by holding that Sherbert and Yoder's test for free exercise claims does not apply to challenge governmental actions that are neutral toward the among religions and generally applicable to all persons. Later still, the Ninth Circuit noted Congress expressed displeasure with Smith, adopted RFRA, and in doing so, effectively granted the Sherbert and Yonder test would be applied in all cases where free exercise of religion is substantially burdened. After laying out this history, the Ninth Circuit introduced a wrinkle that, in its estimation, bore dramatically on RFRA's meaning. The court pointed to another pre-Smith case, Lying v. the Northwest Indian Cemetery Protective Assin. That case involved a First Amendment challenge to a plan to construct a road on federal land near sacred tribal sites. On the Ninth Circuit's telling, Lying set forth a special test for analyzing whether the government's disposition of its real property runs afoul of the Free Exercise Clause. That test, the Ninth Circuit said, permits the government to do as it pleases with its property as long as it has no tendency to coerce individuals into acting contrary to their religious beliefs, and does not discriminate against or amongst religious adherents. In the Ninth Circuit's view, that counts as a substantial burden under RFRA, must be constructed in light of this court's pre-Smith First Amendment jurisprudence, and thus must be understood to subsume rather than abrogate the holding of Ling. The upshot? Though this long series of moves, the Ninth Circuit concluded that the government usually imposes a substantial burden on religious exercises when it prevents that exercise. But thanks to Ling, a different rule applies when it comes to the disposition of the government's real property. In that setting, the Ninth Circuit held a substantial burden arises only when the government coerces people into defying their religious beliefs or discriminates between religions. To be sure, the government's plan may promise the destruction of a sacred site and thus prevent religious exercises from occurring, but the court reasoned none of that is enough to amount to the substantial burden under RFRA when the disposition of federal land is involved. The Ninth Circuit's extraordinary holding easily merits this court's attention. It is far from obviously correct. It poses a question of exponential importance, and it implicates a circuit split. Simply put, this case meets every one of the standards we generally apply when assessing petitions seeking our review. Start with the question whether the Ninth Circuit erred. There are many reasons to think it did. Consider just a few of them. First, the Ninth Circuit interpretation of the phrase substantial burden is difficult to reconcile with the statutory text. As a matter of ordinary meaning, after all, an action that prevents a religious exercise does not just burden that exercise substantially, it burdens it completely. Even the Ninth Circuit seems to recognize as much, acknowledging that, as a rule, the government imposes a substantial burden on religious exercises when it prevents them entirely. Exactly nothing in the phrase substantial burden or anything else in the RFRA's text hints that a different and more demanding standard applies when and only when the disposition of the government's property is at issue. To the contrary, RFRA proceeds to define the exercise of religion to include the use of real property for the purpose of religious exercise. The statute adds that its demands apply to all of federal law without regard to subject matter, and the statute provides that nothing in its provisions shall be constructed to authorize any government to burden any religious belief. In each of these ways, RFRA's term suggests that a law disposing of federal real property is to be treated like any other. Second, while RFRA may have sought to restore some of this court's pre-Smith First Amendment jurisprudence, we have never held that that statute should be constructed to subsume that jurisprudence wholesale. Far from it. In Burwell v. Hobby Lobby Stores, for example, the government argued that RFRA's use of the phrase exercise of religion should be understood to reach only those religious practices this court had recognized to be protected by the First Amendment before Smith. But this court emphatically rejected that notion, describing its implications as absurd, and explaining that by enacting RFRA, Congress went far beyond that this court had held to be constitutionally required before Smith. Similarly, in Holt v. Hobbs, a lower court invoked this court's pre-Smith First Amendment decision to hold that a person regulation prohibiting inmates from growing beards did not substantially burden religious practice under the Religious Land Use and Institutionalized Persons Act. But again, this court firmly rejected that course, holding that the lower courts had improperly imported a strand of reasoning from the First Amendment decisions into a distinct statutory setting that guarantees greater protection. Third, even taken on its own terms, it is hard to see how Lang can be read as setting forth a special test for determining when a government's disposition of land represents a substantial burden on religion. Just search Ling for the phrase substantial burden. You will not find it. Nor did Ling involve a challenge to the governmental plan that seeks to destroy a religious site, as the government's plan for Oak Flat would. Instead, that case concerned a plan to build a road near religious sites that promised to generate noise and considerable disruption, but that also promised to leave those sites standing. In rejecting a First Amendment challenge to the government's plan in Ling, the court took pains to stress that point and the fact that the government's actions would not prohibit religious exercises. To be sure, Ling also stressed that the government's plan at issue there did not discriminate against or among religions. And later in Smith, this court read Ling to support its views that the government does not violate the Free Exercise Clause when its actions are neutral towards and among religions and generally applicable. But none of that has any bearing here. As we have seen, the fact that the government acts pursuant to the neutral and generally applicable law is not enough to satisfy RFRA. Even in those circumstances, the government may not impose a substantial burden on religious exercises unless it has a compelling reason to do so, and exploits the least restrictive means to further that interest. Fourth, at bottom, it seems the Ninth Circuit was concerned that the ruling for Apache Stronghold would effectively afford tribal members a religious servitude on federal land at Oak Flat. And the argument goes, those who have adopted RFRA would not have intended to afford tribes or others that kind of power over the disposition of federal property. Brief for federal respondents in Opposition 16, but unexpressed legislative intentions are not the law. And even if they were to abandon the statutory text in favor of guesswork about unenacted congressional purposes, it is far from clear why we should make the guess the Ninth Circuit did. The truth is, Congress was adopted all sorts of laws restricting the government's power to dispose of its real property. Take just one example, the Endangered Species Act. That law, this court once held, required the government to halt operation of a virtually completed federal dam to protect the endangered snail darter and a previously known species of perch. The court read the act to require that result even though Congress had spent more than $1 million on the dam, nearly $500 million in today's dollars. And our holding effectively divested the government of its right to use what is, after all, its land. If Congress went to such lengths to accommodate the snail darter, why should we suppose it offered less protection to people practicing an ancient faith? Not only does the Ninth Circuit's decision merit our review because it rests on questionable legal footing, review is all the more warranted because that decision implicates both a vital question and a circuit split. No one before us disputes the significance of this case, nor could anyone sensibly do so. As the government has made plain, it intends to clear the way for Resolution Copper to begin the destruction of Oak Flat imminently. The effects of the government's plan promise to be immediate, permanent, and large in scale. An ancient sacred site will be destroyed, replaced by a 2-mile wide crater. The Apaches tell us, without contradiction, that the destruction of Oak Flat will prevent them from conducting religious exercises that cannot take place anywhere else. Indeed, they say, the government's plan will effectively end Apache religious existence as we know it. Even the government has acknowledged that the destruction of Oak Flat will inflict indescribable hardship on the Apaches. But if tribal members will suffer the most, they will hardly be alone. The Ninth Circuit's decision promises to affect many others too. Take the Knights of Columbus. For 60 years, they held Mass on Memorial Day in Virginia's Poplar Grove National Cemetery. But after the Ninth Circuit's decision in this case, the National Park Service invoked the court's reasoning, denied permission for the Mass in 2023, and argued that the Knights suffered no burden under RFRA from the discontinuation of their long-standing worship. Through the Park Service eventually relented after litigation ensued. Seemingly, nothing would prevent it from trying its hand again so long as the Ninth Circuit's decision stands. Nor would anything appear to prevent the government from prohibiting worship at Ebenezer Baptist Church, where Martin Luther King Jr. preached, or at the many other historical churches situated on federal land. Perhaps, unsurprisingly, the Ninth Circuit's decision in this case stands as an outlier. Not a single other court of appeals has suggested that the substantial burden test in RFRA or its sister statute RLUIPA contains anything like the Ninth Circuit's special rule for the disposition of government property. To the contrary, one court after another has held that preventing religious exercise is necessarily a substantial burden on that religious exercise. As Chief Judge Stoughton has succinctly put it, the greater restriction includes the lesser one. Yet, even if no other circuit ever follows the Ninth Circuit's lead, its outlying rule will have outsized effects. That circuit encompasses approximately 74% of all federal land and almost a third of the nation's Native American population. Thanks in large measures to these facts, every circuit decision over the last 3 decades addressed RFRA sacred site claims has come from the Ninth Circuit. Reply to brief in opposition 5-6. As a practical matter, then, if allowed to stand, the Ninth Circuit's holding below will govern most, if not all, RFRA sacred site disputes in this country. While this court enjoys the power to choose which cases it will hear, its decisions to shuffle this case off of our docket without a full airing a grievous mistake, one with consequences that threaten to reverberate for generations. Just imagine if the government sought to demolish a historic cathedral on so questionable a chain of legal reasoning. I have no doubt that we would find that case worth our time. Faced with the government's plan to destroy an ancient site of tribal worship, we owe the Apaches no less. They may live far from Washington, D.C., and their history and religious practices may be unfamiliar to many, but that should make no difference. Popular religious views are easy enough to defend. It is in protecting unpopular religious beliefs that we prove this country's commitment to religious freedom.